The Free Speech Podcast is an initiative of SFLC.in under the Free Speech Project to understand the changing landscape of free speech in an internet enabled world. We have spoken to a host of journalists, activists, lawyers, and scholars to understand and rethink our current landscape around free speech in India.
Hello and welcome to the Free Speech Podcast by SFLC.in. Today we have Siddharth Narrain, who is a lawyer and currently a doctoral candidate at the Faculty of Law and Justice at UNSW Sydney. His research is on the legal regulation of hate speech online, virality and crowds in India. Could you tell us a little bit about your research?
So thanks, Radhika, for having me, and thanks to SFLC for hosting this. I've been following the work of SFLC for some time now, and I'm a big fan of theirs. So it's a privilege to be speaking here. So my name is Siddharth. I'm a lawyer by training, and I'm currently doing my doctorate at the Faculty of Law and Justice at UNSW, and my research is broadly looking at the online regulation of hate speech in India. So one thing about the research is that it is very specific to India, but it has implications for policy, for research, and for academia worldwide. And the interesting thing is, if one approaches the issue of free speech and hate speech from the perspective of India, rather than look at it as a comparison to the US or to Germany, but actually how do those jurisdictions compare to India, then we have a slightly different view where these free speech debates can be seen as something that have evolved in the country as something very distinct and unique in a way, but have really massive implications for this issue in the global south.
So, recently, Section 124A of the IPC, the provisions of sedition, was challenged again in the Supreme Court of India. I think it has been challenged a couple of times by now. Do you think it will stand the test of Article 19.2, considering the change in free speech jurisprudence in Kedar Singh and the increased misuse of the provision? I mean, looking at where we are now.
Okay, so this is a very, very important question and something that all of us are thinking about right now, especially because the Supreme Court has been very interested in this issue and seems to have taken an interest in the constitutionality of Section 124A. Would it stand the test of reasonableness under Article 19.2? And just to give you a brief background to it, what is very specific to India, as I was talking about earlier, is that our right to freedom of speech and expression that is guaranteed under Article 19.1A, which evolved as it evolved in the late 1940s and 50s, was debated intensely in the Constitutional Assembly debates, and was subject to amendment almost immediately after the Constitution came into was promulgated in 1950, 1951. It's the first major amendment, the first amendment to our Constitution, which introduced a restriction based on public order. Besides other things, public order and a restriction based on what is called incitement to an offense. Now, the public order restriction to free speech is basically the one that is relevant to the provision on sedition that we're talking about. And just to give a little background of Section 124A, the main section which defines sedition, which is part of the Indian Penal Code, which was enacted during the British colonial times, and even at that time, this is in the late 19th century, early 20th century, when in colonial India, when these provisions came up in the courts and were being implemented mostly against Indian nationalists, people like Tilak, people like Gandhi, etc. One of the splits that we see in the way that the judges approached this, even in colonial India, was that there were two broad ways of approaching how to define this offense of sedition which is defined in the Indian Penal Code, Section 124A, as disaffection against the state. And broadly, the first approach was to define it very broadly. So basically, any attempt of disaffection against the state would constitute sedition. The second was to approach this a little more narrowly, where it cannot just be an attempt of disaffection, but it actually has to be something a little more than that, where there is where it actually leads to where there is an action and it actually leads to a particular act against the state. So I would say, in broad terms, one could also look at these as kind of, in a way, um, it's part of the larger kind of the way one could look at the way that rule of law really applied in the colonial state. So while obviously they did not apply the rule of law in colonial India in the way that they would apply it in the colonies, was different from in Britain. But the interesting thing is that some of these principles translated in the way in which even the judges felt that there's something about this section that was just too broad and that needs to be narrowed down. And but what happened is that because of the public order exception that was introduced in the First Amendment, this section was upheld. The constitutionality was upheld. And now this is very interesting, because during the debates in the First Amendment, which the debates which I've had the luxury and privilege to actually read in quite detail, thanks to my doctorate right now, read these parts in detail. There was a very strong challenge that came from people in the Constitutional Assembly members, who a lot of the members made a strong argument to the Prime Minister, then the interim Prime Minister Nehru, and the cabinet, saying that, you know what, this is a particularly heinous and vile section, the sedition provision. It has been actually applied to us. It has been applied to freedom fighters. It is applied against Congress and other people who are fighting for independence. And now, why do we want to retain this provision? And Nehru himself actually makes a remark saying that this is a provision that is distasteful, etc. But ultimately, they left it on the statute book. They did not include it as a specific exception to free speech. That was opposed, and so therefore they did not include. They were thinking about it, but they did not. But they did include a broader kind of idea of public order as an exception. And what happened is the courts began upholding these challenges to the sedition section under the public order provision. But ultimately, in 1962, the Kedarnath Singh judgment, the Supreme Court of India, in some ways, read down the provision. So while they upheld the constitutionality in that particular case, the way they did it was to narrow down its application, to go back to the previous split. They went to the narrower split, and so they basically defined sedition as speech that needs a tendency to public disorder, or the use of actual violence or incitement to violence. This goes back to the federal court interpretation. They draw on that and they reject the broader interpretation. Now, so this is like a very important moment, right? The Kedarnath Singh judgment. Now, post Kedarnath Singh, now we're talking about in the 70s, 80s, 90s, and now the Supreme Court has further, in its broader free speech jurisprudence, but also particularly related to sedition, issues like hate speech, sedition, etc., public order related speech offenses, has further narrowed down this idea of what does it mean for a tendency to public disorder. Because it is, as you can imagine, it's a broadly framed term. They have further narrowed it down, and just to simplify things, I would mark two ways in which they have narrowed it down. The two crucial ways is, one is they have said that there has to be a proximate connection between the speech and the violence, the tendency to violence we're talking about. And this is understood through a legal test called the spark and a powder keg test, which says that the connection between the speech and the violence that's alleged to result cannot be hypothetical, far-fetched. It has to be proximate, and you have to prove that connection. So in this way, it narrows down what kind of actions. The second way they have done it is they have the Supreme Court has over a period of time reiterated that the audience for the speech must be judged by a reasonable person who is strong-minded. You cannot look at the target audience as somebody who is weak and vacillating and who's very easily sensitive. So the audience has to be a robust audience, and this becomes very important as well. And the third way in which they have also narrowed it down is the court has also made distinguished in Ram Manohar Lohiya's case. They have distinguished between law and order and public order. So law and order is a broader category, and public order, they have said, is a smaller category of speech. And lastly, most recently, in the Shreya Singhal case, which has to do with online hate speech on the internet, the Supreme Court has come up with another test, which has repeatedly been cited, which makes a distinction between advocacy and discussion and incitement. So the speech that is alleged cannot just be a case of advocacy and discussion. It actually has to amount to incitement. So these are just to give you examples. There's more case law, but this is to give you an example that over a period of time, they've further narrowed down what could possibly constitute sedition. But even though the court has done this, what we have seen is that there has been a rampant over the last few years, especially. But even I would say, statistically, there is still studies being done by Article 14 and other organizations. But what we have seen is that there's a rampant misuse, blatant misuse of the section by different governments, by the state, I would say, where this section is used not so much to actually put people in jail, because it's difficult to prove sedition in the court, but it's more to what legal experts have pointed out, to create a chilling effect. And a chilling effect basically means that once you prosecute a very prominent person or a dissenting voice or a creative artistic voice, something that you don't agree with, once the state begins prosecuting these people, it creates deterrence value. It makes people scared. They're also increasingly being painted as anti-national. So there's a kind of a way in which people who are charged with this particular section are also portrayed as anti-national, Deshdrahis, and so on. And so you have this particular situation where then people will be more hesitant to speak out, to speak their mind. And so this is a situation which the court is now cognizant of. And there have been a couple of examples recently where prominent news organizations, journalists, etc., who have been targeted with this section. And I think they're not the only ones. The section is used very broadly against all kinds of people. But of late, the Supreme Court has made some observations which I think point to the possibility that there might be a relook at the fact that it has been held constitutionally valid. So I would say that this is an opportune time for the court to relook this jurisprudence, and there is enough legal as well as increasing evidence, statistical, legal evidence, and evidence of misuse of this section, which could be used to build a strong case that Section 124A must go.
So there is still some hope. But to move on to my next question, how is hate speech understood in India as opposed to other jurisdictions? If you could explain how it is a reasonable restriction on free speech under 19(2) of the Constitution.
Sure. So hate speech is a topic that I have been engaged with over many years now, and it is the topic of my PhD dissertation. So you're basically asking me to explain my PhD dissertation in a few lines, which we're supposed to know how to do. But on a more serious note, um, so hate speech is it's related to the question of sedition in a way in India. It's closely related simply because both sedition and hate speech laws evolved from the same penal provisions during colonial times. Many of the crucial hate speech provisions were offshoots of the sedition law, and sometimes you see the two applied together even now. So they're close cousins, I would say. The difference in the Indian context between a section like 124A, that is sedition, is that it governs the relationship between the state and the individual, while hate speech is more focused at the relationship between individuals, between communities, especially between communities such as religious communities, communities based on other identities, increasingly as well. But in India, of course, we have understood this. A lot of the case law has been around religion, caste, and other social identities. Um, so, hate speech is interesting because there's a distinction, there's a disjunct between what we broadly understand as hate speech and what the legal understanding of hate speech is. And the term hate speech itself, uh, according to the research I have done, according to the research I have seen, I have read, the term hate speech itself um, emerged as a term that was used by critical legal scholars in the 80s. It's a pretty recent term. The critical legal scholars in the United States who were making a case for um, um, speech targeting minorities, speech attacking minorities, racist speech, etc., to be regulated by the law and not protected under First Amendment protections. That's the context in which the term hate speech first begins to circulate. Then it circulates outside of these circles and moves on to a much broader understanding. So when we actually read the term hate speech, is more in the newspaper or when people talk about hate speech, we use it very loosely, the term, right? So we think about it as, okay, when a group is targeted or attacked by another group, or a vulnerable group is targeted and attacked by another group, a dominant group. So there's a relationship of power that's involved as well. However, the legal definition of hate speech is used. One has to use it a little more carefully. Internationally, a definition that you see in international standards, international human rights standards, and comparative jurisdictions, you see a definition that more or less corresponds to this. So it talks about a dominant group that is targeting a less powerful or a vulnerable group, and targeting and inciting hatred or violence, inciting discrimination, hostility against a more vulnerable group. So broadly, to understand it broadly. In India, we do not have this sort of definition yet that corresponds exactly to this. And also internationally, you see the law has taken on what evolved in the US as looking at protected characteristics, certain characteristics such as religion, race, etc., which are considered to be protected under hate speech laws. In India, again, it is slowly seeping into our jurisprudence, but we have not yet explicitly enacted laws of this nature. Instead, what we have is we have a large number of sections, both criminal and civil, which use broadly this language of one group targeting another group. And this is again, this particular language that we see is language such as what you find in section 153A of the Indian Penal Code, promoting enmity against groups. Section 295A of the Indian Penal Code, wounding sentiment, religious and other sentiment. Other sections such as section 505, etc. So the range of sections in the IPC, which I think together constitute our hate speech laws, as well as other laws such as you find the same language in election laws, in laws that protect vulnerable groups such as scheduled caste, scheduled tribes, and SC/ST Prevention of Atrocities Act. You would find it in broadcast and media laws, internet-related laws, where these specific media-specific laws also have this sort of language that is provisions that actually protect against hate speech. However, but my research has mostly been on the penal provisions, 153A, 295A, etc. But this is a broader understanding of how we understand hate speech. Now, again, in the case of hate speech, a lot of the hate speech provisions were also challenged post independence. And similar to 124A, there was a similar debate around 153A, which is promoting enmity between groups, simply because this was another provision again used to target Indian nationalists. So the British colonial authorities often used this provision against Indian nationalists also, saying you're inciting hatred against based on race, for example, against the white minority. Sometimes they would use it like that, or sometimes they would use this instrumentally, they would use it. So for those reasons, again, 153 was a provision that was heavily opposed. But again, similar to 124A, it stayed on the statute books and has been upheld by the constitutionality has been upheld as a reasonable restriction under 19.2. The other hate speech provision which I would include is 295A, which is wounding religious sentiment. Again, a controversial law in many contexts, but in India and South Asia, we see this as a provision that came about in the 1920s as a response to polemic attacks and satirical attacks based on religion, where because of competitive nature of religions that promoted each other, they would have these vituperative pamphlets, etc., which would attack other religions, and they would attack the leaders of religions, people revered by religions or religious figures. And initially, the courts, the Lahore High Court, for instance, when it was challenged in a very major case in the 1920s called Rangila Rasool, which related to a satirical attack on the Prophet in a pamphlet, the Lahore High Court upheld the legality of sorry, it was the opposite. It struck down the law, saying that while the law allows for attacks on people, that is groups. So, for instance, if you attack a group of people based on their religion, it does not allow for protections against attacks on institutions and concepts. But this led to a lot of controversy because sometimes the distinction in the South Asian context is not so clear. So therefore, the law was then enacted by the legislature, and that law is, I would say, less controversial in the Indian context and has continued to be very much part of our hate speech jurisprudence. In a country like Pakistan, it is more controversial and has led to it being applied as blasphemy. That has they have enacted laws in that context. But in India, mostly, except for Punjab, which recently has a very blasphemy-like law that has been enacted. Otherwise, it is generally used 295A. It is meant to be used to prevent such kind of vituperative attacks. But again, it is often used instrumentally. 295A is another law which is often used instrumentally by 124A, not just by the state, but by private citizens and groups who of late have been claiming that works of art or works or speeches or basically speech broadly and expression are hurting their sentiments and wounding their sentiments. Something which people have been writing about as also creating a chilling effect. Also creating a chilling effect on speech more broadly. So yeah, this is a more kind of background to the particular distinct nature of hate speech debates in India, which I'm giving you in a very small nutshell.
Yeah, yeah, yeah. Yeah, even like all the latest Netflix and series on Amazon Prime, any streaming platform. There's so many with the new ethics codes and guidelines. That's also, I think a lot of it was just because people could not digest other opinions and them writing against it. So many cases in courts. That also reminds me. I think Rangila Rasool was eventually shot dead somewhere. Um,
You mean the author, the
yeah,
printer?
he was.
Yes, the printer.
Yes.
The printer was killed, and in fact, the person who killed him is still considered to be martyr in certain parts of Pakistan, and is considered to be a martyr. But the interesting thing about Rangila Rasool, and this is what historians like Neeti Nair and Julia Stephens have written, is that despite all of this happening and being very controversial at that time, in some way it was a pragmatic solution. It was a pragmatic solution based on the context where the legislature, and even at the time, the legislature, there were concerns raised around creative speech against by the press, by academia, by people from academia, etc. So there were concerns raised about what are the implications of this law and how this could be vague, etc. But in the long run, it did lead to a certain kind of a resolution saying that yes, we do recognize that there are certain sensitivities that should be looked at, but at the same time, they are also subject to the same test that we are talking about, that I talked about, which relate to sedition, the test of spark in a powder keg, the test of the hypothetical person, the audience. It can so when you're subjected to these tests, there is a certain a way in which you narrow down the scope. And again, this the same problem arises: is what happens when people use it instrumentally, when it's more used to harass and to create a chilling effect rather than to actually put people behind bars, etc. And also, who is it being used against? Who who is employing these laws against who? Eventually, if you start looking at these factors, you will realize that it is often used instrumentally in India.
Right, right. Putting all of this slightly in context of social media, because most of our now hate speech is like social media is sort of a public square now. Where do you see that? What role does social media platforms like Facebook, Instagram, especially Twitter, have played in all of these debates? Where do we figure in terms of free speech on social media, with of course in context of the new guidelines that have come out as well?
So this is a very complicated terrain. There's no simple, straightforward kind of response I can give to this. But uh, one aspect of this, which I find very important, and I want to stress, is that with online speech, especially speech on these platforms that you're talking about, there is uh, something different about the reach, the speed, the what we call virality, the way in which this speech circulates on these platforms, and also it's related to the political economy of these platforms. What academics, authors writing on the subject have called very much embedded in platform capitalism, which anybody who's following this issue and reading about it would be aware. For instance, how platforms depend on their revenue, often depend on eyeballs. It depends on how much they can actually circulate, how much this speech can circulate, how much their content can circulate. So their revenue is very much based on getting more people, getting content to be viral. And now there's a tension here. The tension arises because in some cases the speech is toxic, the content is toxic, and 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 I guess it's not something that I need to tell anybody. People are following this very closely, and we know the entire controversy, internal documents leaked. We know that there's intense pressure on platforms across the world. It's not just in India, across the world. Recently, even the Delhi Assembly has summoned a Facebook, one of the top Facebook officials in India, Facebook India, to answer, which I saw online, which is available on YouTube, where there was an exchange between the Assembly, the Delhi Committee on Peace and Harmony, and Facebook India representative, exactly around these questions and around the role of platforms during the riots in Delhi that happened 2 years ago. And so this is just an example of the just the role that the influence and role that platforms have. And this in some ways has made this issue of hate speech especially even more of an issue that is both of concern, and that is basically in something that policymakers are grappling with. Of course, the question then arises is, how do you deal with this issue? And across the world, we have seen governments trying to regulate platforms, saying that you need to make them liable and regulate them. But the question arises is, in the Indian context especially, uh, what are the laws that are being passed to regulate these platforms? What is the legality of that? What's the constitutionality of these laws? What would be the effect of these laws? Are they reasonable? Are they being tailor made for this particular issue? What happens once you pass these laws? Um, can the same laws then be used to suppress uh, dissenting speech? The same problem we talked about, will they be used instrumentally? What will be the effect of these laws? So you have this question as well. So on the one hand, the civil society organizations like SFLC, the Internet Freedom Foundation, and others have been very rightly so asking for platforms to regulate speech better, especially in contexts like India, where to put in more resources, to put in more language expertise, etc., which slowly, both through their independent oversight board, etc., these measures are implementing some of these measures, and that's part of my research. I'm also tracking some of these internal measures that they are implementing. But the civil society is putting this pressure. But at the same time, uh, what happens when the state puts this pressure is the question. What's the relationship between the state, civil society, and platforms? How do we even understand civil society itself? Our understanding is now more complex as it splits based on ideology. And the state's ideology, the state's own position, the relationship with some of the groups that are promoting hate speech, it's also under scrutiny. So in this sort of atmosphere, which is a complex atmosphere that we're entering, a kind of phase, then then one has to be quite nuanced and quite careful about how to approach this issue in the Indian context, is what I would basically say. But there's obviously a lot more ongoing debate and research on this.
Yeah, you're right. I think it's this entire debate. I mean, you get into it, but there's no way to get out of it. There's just too many things happening, too many things we know, too many things we don't know. And that, of course, makes it much more complicated. So, my last and final question to you would be, Siddharth, is do you think that do we still need reasonable restrictions when we talk about free speech, or should our free speech rights look like the First Amendment without any reasonable restrictions?
Look, I'm not a free speech absolutist. I've never been, and that is a more general sort of a thing. And I don't think free speech absolutism really works. Even the First Amendment, those working in the First Amendment have pointed out, even American scholars, US scholars, legal scholars have pointed out that the First Amendment is not absolute either. Even under the First Amendment, you have many restrictions, and you have laws that do restrict certain kinds of speech, even with the First Amendment. But the point is that Indian law has evolved under a particular context. It has evolved through the constitution making process. It has evolved over a period of time through the Supreme Court's jurisprudence in this area, and we have reasonable restrictions. We also have a robust we have a very robust doctrine in this area. Right? So the courts, based on the constitutional provisions, based on the historical debates, have evolved a particular position where they have uh, provided enough material ammunition to actually for us to use it. But the culture of free speech, the way that society uses this, the way that we as middle class citizens, the way as we as citizens more broadly, that we engage in this, right? So that is something. So one, so the Upendra Bakshi, for instance, talks about constitutionalism not just being about the text, but it's also about how the legal community. It's also about how people, the culture, the constitutional culture that evolves. It is also about the state. What is the state's politics? So you have all these things that come into the picture, and the reasonable restrictions uh, are there. There's a particular history to it, but at the same time, you also have this sort of robust doctrine that has evolved very much from this history of reasonable restrictions. The question is not so much whether we need, that is very much the basis of our free speech jurisprudence, but the question is how do we then further this kind of culture of a robust debate, of a culture of a robust speech culture in India within this framework, where one will still have the freedom to say what one believes in, to challenge ideas, to discuss ideas, to speak truth to power, as they say, and how one can mobilize the existing free speech jurisprudence towards this end, and pragmatically whether this is what are the how do we do this, not just theoretically, right? So how do we then actually promote and instill this, and yes, so that's what I would broadly say. But as of now, um, while we have, there's a certain kind of disjunct between the law and the statute books and this culture. So there, while the law and the statute book there's something robust about it. Increasingly, the culture of free speech is being eroded. So how do we bridge this gap, and how do we address this? And speech on social media, which you rightly pointed out, complicates the matter. You have platforms as a very important players in this space. So how do we then address this, and how do we address it in a way that's sensible? So that would be my observation.
Thank you, Siddharth. I think this has been very insightful. I would encourage all of our viewers to go check out the Free Speech Tracker, which is available on the SFLC website. It's a crowdsourced initiative, so we're always looking for people to find bugs in the tracker. Tell us if you're doing something wrong, if you're doing something right. So please go check it out.